You're recognized on Senate Bill 1931.
Thank you, Mr. Chairman. And 1931 has an amendment that is 15301.
Is there a motion on the bill? It's been moved by Senator Kyle. Is there a second? Seconded by Senator Bill, and you're recognized on the amendment, Senator Massey.
Thank you, Mr. Chairman. And this bill is called the Foster Care Support and Continuity Act. And basically, the amendment does rewrite the bill, and it does pretty much four things. It increases social support for foster children after reunification with their biological family or relative, and in that it would enable that the former foster parent may maintain contact with the children through regular visits as determined by the court, and if the child expresses an interest that they would like to maintain that relationship. It also, if in the case of an emergency placement, and this is often done, but this is put into code, but if in the case of an emergency placement, that the department would look at a former foster family if there was a significant relationship when they were considering that emergency placement. It also authorizes the Department of Children's Services to disclose a former foster parent's name to a treatment provider or other necessary party if the former foster parent has relevant information regarding the child's medical or social history. And then it also grants a foster parent who maintains physical custody of a foster child for 12 continuous months or more, or 15 months out of the previous 22 months, legal standing to file for permissive intervention in any custody hearing involving the foster child. This step is a positive step forward for foster families and foster children while in and after state custody. I want to thank DCS. We worked with them. We also had discussions with some folks that had concerns about this bill, and we brought those before DCS, and they actually helped rewrite the bill to get it into the format that it is in today, to make sure it was consistent with what we're doing and what needs to be done. And we've also worked with Judge Tenn Irwin of Knoxville to help with this bill too. So I want to thank both, especially thank DCS for the work that they've done in the administration on this bill, but I also want to thank the folks that have expressed some concerns, because that helped us work out some of the kinks in the bill too. So,
is there a motion on the amendment? Okay, it's been moved by Senator Kyle. Is there a second? Seconded by Senator Bill. Discussion on the amendment. Senator Bill.
Mr. Chairman, could we, I've just got one quick question for DCS. Could we go into recess so I could ask him one quick question?
Without objection, we'll go into recess. Chairman Bell, you recognize.
Thank you, Mr. Chairman. Section 2, where it says for the purpose of promulgating rules, forms, policies, this act shall take effect becoming law. All of the purposes July 1st, 2018. Have you got, has your department got time to put in place all the rules, forms, and policies between now and July 1st in order to effectuate the law?
Mr. Marty.
Chairman Bell, Helen Rogers with DCS Legal Office is heavily involved in our rule promulgation process, and she's assuring me that we do.
Okay, thank you.
And Mr. Marty, we've had 3 bills this year, and we have certain other ones in years past in regards to rights of grandparents. We have one of those this year. We have another one in regards to the rights of step-parents, and then this one we have the third one in regards to foster parents. And in all of those instances, of course, we have tragic circumstances where the child has been placed with someone who is not one of those relatives. And traditionally, the standard for the court has always been to look after what is the best interest of the child to make a determination as to whether or not those grandparents, foster parents, or step-parents can be seen. This bill has language that may intimate that, or it may not, and so I wanted to get your opinion on what would be the practical application of this bill that would differ from current law in regards to looking after what is the best interest of the child in a court's determination.
Chairman Kelsey, I didn't introduce myself at the start. Russell Marty, Director of Legislation for the Department of Children's Services. We did have some initial concerns with the legislation, and we were very happy to work with Senator Massey to address those concerns, and she was very good to work with. I do think one of our initial concerns was on the portion of the original bill that allowed a foster parent who maintained custody for a certain amount of time to have standing in any custody hearing involving the child. With the amendment, that concern has been addressed, and it now allows for a permissive intervention, which is essentially the ability of the foster parent to petition the court, and the court would have to grant them the right to intervene. That doesn't differ a lot from current practice. In a termination for parental rights hearing, for instance, if the child is in the physical custody of the foster parent, they arguably could and would be granted permissive intervention in situations like that. In a dependency and neglect hearing, a foster parent could also, any party could petition the court on a situation like that. That doesn't differ substantially from current practice. Another portion of the bill that we initially had concerns with has now been deleted from the bill, and we thank Chairman Massey for that. That dealt with a portion of the bill that allowed a biological parent to create a form to voluntarily surrender their parental rights. I can say that with the changes in the amendment, that we do feel like the best interest of the child is preserved.
Okay. Well, thank you very much for that testimony. Senator Lundberg.
Thank you, Mr. Chairman. Section D1. Is that what you said you had a concern about?
No, Senator Lundberg. Section D1 of the amendment resolves the department's concerns.
Mr. Marty, I appreciate your working with the sponsor on this, and can you do the same on the other two bills before next week?
I'll be happy to work with any sponsor who requests my help.
Well, it would be the request of the chair that you try to work with them, whether they request your help or not.
Chairman, I'll be happy to help facilitate it.
Thank you very much, Senator Massey. You're always good at that. If there's nothing further, then we're back in session. We're on the amendment that has been moved and seconded, and is there discussion? Senator Harrison.
This is on the amendment, Mr. Chair.
The amendment that makes the bill.
Thank you, Mr. Chairman. So part of the bill allows the biological parent to object to the foster parent's continued relationship with the child. Do adoptive parents also have the same right to say no to a continued relationship with the child?
Senator Massey.
This bill just addresses the biological parents, so I'm not sure. I mean, it does just address the biological parent that's opposed, but it also, in the first part, talks about, the first part of B talks about that if the foster parent has had that ongoing relationship for at least 6 months, they may, not shall, but they may, that's one of Chairman Bell's fun words, but they may maintain some communication if the child expresses a preference for that and the court agrees, so it has to be determined by the court, and it does not jeopardize the health or welfare of the child. So I'd say that would come into play if it was an adoptive parent, since the other part specifically says biological. But it's still, the court has to agree to it.
Thank you. Thank you.
And members, I forgot we had more testimony on the other side of the bill against the bill. So without objection, we will go into recess to hear from Ms. O'Donnell of the Tennessee Bar Association, and you are recognized. If you could, please state your name and title for the record. And our policies are 5 minutes maximum, though you do not have to take that full time. You recognize.
Thank you all. I appreciate your time today. My name is Stacy O'Donnell. I'm a private practitioner in Lawrence County. I'm a child welfare law specialist recognized by the Tennessee Commission on Continuing Education and Specialization. I am a foster parent. I am an adoptive parent who is adopted from foster care. I'm the section chair of the TBA section on children and juvenile law. I'm not here on their behalf. I also have participated in various work groups relative to juvenile law. I'm here today to first thank you, especially Senator Massey, for working diligently to recognize the voices of foster children, foster parents, and the families involved with child welfare. Ours is not an easy industry. In fact, if you think about it, we probably need to have our own services given to us because we wake up and decide to do this every day. I found that the most rewarding part of my job as a foster parent is getting to work with my children and helping them grow and recover from a traumatic situation that led them to be in my custody. As an attorney, I practice about a third of my practice as a guardian ad litem, meaning I represent children who are subject to the juvenile court of our county, whatever county that might be, to determine what their best interest is and advocate for that best interest in the DNN setting. I appreciate this committee's diligence in considering this bill, Senator Massey's diligence in creating it, presenting it, the department's diligence in working with everyone cooperatively to present things. I just have a few concerns because we are kind of relatively new to addressing the issues of foster care, and I have some questions about this bill that I feel like make it unintentionally create more problems as the process were to move forward rather than fix them. First, let me just acknowledge that we need to protect the emotional bond of children going through foster care. The dependency and neglect process is not an easy one. If a child's in foster care, it's because every other alternative has been exhausted and was found by the court or the department or both to be inappropriate for that particular child. Foster care is not an easy place to be, whether you're a child or a parent, a foster parent, or a member of the team. This particular bill allows that emotional bond to continue, and I appreciate that. We need to be focused on children's emotional bond with the parties that help them heal. We need to be focused on the child, period. The Title 37 is specifically passed with the intent of protecting the child's best interest. Unfortunately, under current federal mandate, we have to do that with the structure of returning children to parents as a first priority. Reunification of family is supposed to be a first goal anytime a child is pulled into foster care, and although we can work dual goals, including adoption, exit custody to live with a relative or a kin, another placement, subsidized permanent legal guardianships, planned permanent living arrangements, etc., we have to work to reunification. I'm concerned that the language of the bill, specifically with Section B, puts a lot of pressure on the child to exercise a reasonable preference. We have a child that's come through a series of traumas to begin with, and then we're relying on the child to tell us in that role as kind of decision maker whether or not that child has a reasonable preference for a family that basically, to some degree, and I use the word safe knowing that that's hyperbole, but was a safe place when things were not so safe for them. They were the first place they went when that child was experiencing a trauma, not the least of which was being removed from a home that was abusive or neglectful. I'm concerned about that. I'm concerned about the resources of a biological parent to contest the request of a foster parent coming in. This bill, as I read it, contemplates that a child will have been removed from foster care, placed with a biological parent or a fit or willing relative, and then at that time, as long as things are agreeable, it works out fine. If it's not agreeable, contact between the child and the foster parents, then at that point, the foster parents can seek from the court some intervention that would allow that contact to continue. My question is, at what point does that become necessary? Can a foster parent logically, under this bill, come into court weeks, months, years after that child has left foster care seeking contact? If so, is the parent, because the juvenile court, through the dependency and neglect action, will continue to have jurisdiction over that issue until the matter is removed by motion of the parties, at that point, will the biological parents or the custodial parents be entitled to appointed counsel? I don't know. There's no provision for a guardian ad litem anywhere in this bill. There's no one representing the child's best interest to determine whether this child's preference is based on circumstances that have begun in a power struggle between the foster parents and the biological parents. In our line of work, it's hard to keep children out of custody battles. It seems like to some degree this bill, as it is, creates one between another third party standing. Right now we have grandparents' rights. In some circumstances, step parents can get visitation rights. We're creating another carve out for foster parents. I do appreciate subsection D 1 and 2, and I think that they can be added to the foster parent bill of rights. I do have concerns that we're allowing permissive intervention for third parties who are not otherwise recognized legally in any other setting. I appreciate your time, and will entertain any questions if you have any.
Thank you, Ms. O'Donnell. Questions? Senator Harrison.
Why are you in favor of D1? And I think part of why I struggle is maybe I don't think I understand what permissive intervention is, because as I read D1 without that kind of informed opinion, D1 seems to be the same as the rest of this, other than D1 says it's for foster parents that have had a longer relationship with the child. So why are you okay with D1?
Thank you, Chairman Harris. Let me clarify that to some degree. I had a 30-second card, so I was speaking incredibly fast. I'm okay with the intent of recognizing through the Foster Parent Bill of Rights that we recognize as a legislature that foster parents play an integral part of that child's healing and this family's healing. And I would suggest that the language includes something about we don't want to prohibit contact should it be agreeable under certain circumstances or other circumstances. I believe the language specifically about permissive intervention is something I am opposed to, because we are creating at that point an opportunity for a third party to come into a custody battle. And under this legislation, I would consider the example of a foster parent has a 1-year-old child who remains in their home until that child is 2 or 2.5. The biological parents regain custody after 18 months in foster care, for instance, let's say, and then those parents divorce when that child is 13 or 14 years old. Under this statute, as proposed, there would be nothing to prohibit the foster parent from coming to the divorce court and asking for permissive intervention based on a relationship that they had known. Maybe those foster parents continued to have a relationship with the child. And that's certainly an extreme example, but it's one that certainly could happen. Anytime we're creating an opportunity for another party to join in litigation, especially in DNN actions, especially in post-DNN actions, we've got to ask ourselves, first of all, are we allowing a third party to supersede the superior parental rights of biological parents? Under Green v. Green, DNN finding doesn't necessarily attach for life. We can have a finding by juvenile court that a child is abused or neglected or dependent neglected, and then months later on de novo appeal, that child may not be dependent neglected anymore. So that's not a finding that's going to follow the child necessarily in perpetuity, but this bill would allow the relationship between the child and the foster parent to continue to be subject to court scrutiny for the duration of that child's minority, it appears.
Senator Harrison.
Thank you, Mr. Chair.
Further questions? Senator Massey, I may have spoken too soon after the last witness. I think Ms. O'Donnell raises some very serious concerns that would cause me to not be able to support the bill at this time. Do you have any response to some of the issues that were raised?
I mean, I think these don't automatically grant these things. There's Mays in there that in that first part that she was discussing, it is up to the court to decide if they're going to grant. If it's a 2-year-old that just says, I like so-and-so, it doesn't automatically give them we have to trust in our courts to make those determinations if it is a reasonable thing to proceed with and in the best interest of the child. I don't know if our DCS would like to come up and weigh in on any of this also, and I'm happy to work on it further if need be.
Mr. Marty, do you have anything further to add to the conversation at this time?
Thank you, Chairman and Committee. Russell Marty, Director of Legislation for the Department. Specifically on the last piece under D1, the permissive intervention, certainly recognize those concerns on the front end. The permissive intervention certainly allows for a court and a judge to lay eyes on that case. So in the event of the hypothetical that was laid out, a judge would be able to grant that instead of being automatic standing.
Okay. Anything further? Yes, Senator Harrison.
Thank you, Mr. Chair. Where are these kids? Where are these kids that want to have continued contact with the foster parent or former foster parent? These kids are adopted, so they're in an adopted home, or are they somewhere else? For example, back in state custody.
Ms. O'Donnell.
Thank you. I think that's an excellent question, Chairman Harris, and one that I don't believe is addressed specifically by the bill. For instance, I am my adopted daughter's foster mom. We were her only placement. So the adoption statute under Title 36 addresses post-adoption contact with previous family members in the event that the child is adopted by family. In this particular legislation, there really isn't any clear-cut answer as to what limitation would exist as to where that child would have to be. The first subsection there indicates that if the child is placed with a biological parent or a fit and willing relative, then that permissive contact would occur. Under subsection D, it doesn't really indicate under what limitations the custody action would have to occur. So if a child is adopted by two parents, would a former foster parent then have a right to come to court and ask to permissively intervene in the custody battle between the adoptive parents or not? When I was reading it, I primarily focused on hypotheticals involving children who are in foster care and then reunified under a permanency goal not specific to adoption. But I believe that you really have stepped out of the box and identified that this bill doesn't seem to only apply to those situations, and there may be questions about foster children who are adopted as well.
Thank you, Mr. Chair.
Further questions while we're in recess? Hearing none, then we thank you both for. Oh, yes, Senator Bowling, sorry.
Thank you, Mr. Chairman, and thank you very much. I can tell you're passionate on this because you've lived it, and I appreciate the way you speak in outline form almost. It helps me to understand, and very, very organized thought process, when not to be confused with mine, and I apologize. In this bill, what is contained in this bill that couldn't, the positive aspects, the simple aspects, couldn't be done in an informal capacity between two adults who have genuine concern and care for the well-being of the child? The child was placed back with the biological parent, the foster parent. The biological mother at that point is in control and being a responsive parent and adult, and sees the child. It would help the child to maybe have little visits or to have a little bit of that continuity or whatever. And if it were agreeable with both adult parties, is there any law that prohibits that now?
Chairman Boland, thank you for that question, and you're absolutely correct. There is nothing that prohibits that specifically in statute that I'm aware of, and I'm, like I said, a child welfare specialist practicing in the Title 37 specifically every day. Mm-hmm. Not only is there nothing prohibiting it, it's very common in my area. Resource parents are often a follow-up resource to biological placements after reunification because they know the child so well. The biological parent or fit and willing relative often becomes overwhelmed at reunification. Mm-hmm. They seek out that support, and there's nothing prohibiting that. And certainly that can continue, and to some degree, the court has some discretion to encourage that under the disposition statute, in my opinion. There's nothing prohibiting that as well. And so for that reason, I also think that we need to tread real carefully in what specifically we legislate as opportunities that should be taken or could be taken.
So without putting words in your mouth, this could almost be a solution looking for a problem?
Yes, ma'am.
Thank you.
Further questions for our guests? Okay, hearing none, then we'll go back into session. Ms. O'Donnell, let me also echo Senator Bowling's thank you. We do appreciate your willingness to serve as a foster parent.
Thank you for your time. I appreciate y'all.
Senator Massey, now that we've heard some of these concerns, would you like to perhaps take a week to see if you can get some of them worked out?
That would be fine, Mr. Chairman.